I'm delighted today to welcome you to this ESIL lecture by Professor Attila Tanzi. Professor Tanzi is the chair of international law at the University of Bologna, and he's a well-known international law scholar, working in particular in a variety of fields: international environmental law, international investment law, international organizations, just to name a few. He's also a practitioner of international law. He's in particular the chair of the implementation committee of the UNEC Water Convention, and he has extensive experience in arbitration and interstate disputes. Today, this lecture has been organized by King's Forum on International Dispute Resolution, so it's a forum that has been created a few years ago to complement the LLM that we have specializing in international dispute settlement. It's also sponsored by the European Society of International Law, and I have to make you aware that this lecture is going to be recorded, and the recording will be put on the website of the European Society, the objective being to share the knowledge that we will get today to a wider audience irrespective of where they are. So the structure of this talk today will be as follows. Professor Tanzi will speak for around 50 minutes, and we will then have some comments by a barrister specializing in energy law, and in particular in the field of hydropower, oil and gas, and major natural resource development projects. So we're very delighted that Jane Davis-Evans has made some time out of a very busy schedule, I can imagine, to come and make a few comments on Professor Tanzi's talk. So thank you to our two speakers, and Professor Tanzi, it's a pleasure to have you here. The floor is yours.
Well, thank you very much, Leslie, and for the kind presentation. I should also thank the forum for this invitation, and I suppose I should be thanking also Dr. Philippa Webb for having transformed what was meant to be a rather informal talk into an ESIL lecture. And I also thank Jane for having been generous enough, indeed, with her time to come and comment and give the real thing and put some flesh to the bones here. In fact, I will go to the bone here. The construction of infrastructure necessary to hydropower industry and its operation are very highly likely to cause international disputes. And when we talk about international, we have to think of different layers of international bodies of law which may govern dispute avoidance exercises, attempts, or dispute resolution when the time comes that a dispute is inevitable. I am referring to international water law traditionally, international rules on domestic remedies for transboundary harm, including conflicts of laws, then international investment law, and human rights law. The choice of today's topic and the organization of this lecture very much reflects the inspiration I got from the reading of the impassioned reception speech given by Hydroelectric when he received a very much deserved Hague Prize in 2004. His speech revolved around the importance of international law for the legal practice, and conversely, around the importance of the practitioner's expertise for the promotion and application of international law. Professor Rosen asked himself the question whether the average practitioner is qualified enough in international problems when professional advice would so require. The answer was in the negative. And he further commented as follows, I quote, "I do not think that an attorney can be fully qualified if he or she is unable to identify an international element in a client's problem. I do not expect every attorney to be able to solve that international law problem, but the least that can be expected is that the attorney will identify that the international law problem is part of the complex to be resolved, unquote. And it is against this background that I have chosen to offer a broad brush illustration of different cross-cutting aspects of hydropower relevant to different branches of international law, rather than to focus on an in-depth analysis of one of them. This choice also purports to conform with one of the points advocated by Judge Greenwood only a few weeks ago in his lecture given at the Honourable Society of the Inner Temple. There, Judge Greenwood advocated that the scholarship should try and contribute as much as possible to constructive elements of legal realism to the international law process. The lecture will first highlight the peculiar features of hydropower industry that render its projects susceptible to produce legal disputes under different regulatory settings. A brief illustration will follow of how each of the four bodies of international law in question may apply, and in so doing, the entanglement will be emphasized between the state and non-state interests involved in the relations governed by the rules and principles in hand. Hydropower partakes of the general fourfold division of the energy economic process: electricity generation, transmission, distribution, and sale of electricity. Though special engineering, hydrological, financial, environmental, and social considerations apply that provide the peculiar context for appropriate legal analysis on a case-specific project basis. The hydrological factor of the generation process usually requires the construction of one or more dams or dikes. Often this involves the diversion of one or more water courses, the realization of similar infrastructure processes and projects may produce significant environmental and social impacts, which may be absent or of a lesser seriousness in other energy-related projects. It adds to the specificities of hydropower the fact that more often than not its impact is of a transboundary nature, given the transboundary nature of a large number of watercourses which supply the flow necessary to rotate the turbines. On a comparative advantages list of hydropower, one is to note that once the dam is built, the energy production process is relatively inexpensive, and that it involves a low level of pollution. The energy production process is generally more reliable and constant than wind, solar, or wave power. Water can be kept in store upstream to cope with peaks in demand. Dams may also be used for flood control or irrigation. Therefore, the costs of building and maintenance of the dam may be shared between several economic users and actors. On the list of the downsides, as already alluded, hydroelectric power plants need dams. They are very expensive to build. Large ones tend to flood extended areas upstream, thus resulting in reduction of the land allocated to agriculture and pasture and in the displacement of people. Water quantity downstream is usually diminished, thus inevitably affecting water quality due to a diminished capacity of self-depuration in the water course. All these may produce significant adverse effect on plant, animal, and human life. Furthermore, most of the advantages of hydroelectric power may be curbed by the effects of climate change, especially regard to evaporation and drought. Until the turn of the last century, in many countries, electric power has been generally under public ownership and in a context of natural monopoly. Market reform through the 1990s has allowed for private electric companies to be separately involved in individual segments of the hydropower economic process. Against this background, I will address the four bodies of international law which provide guidance for the avoidance or settlement of hydropower-related disputes. And I will start with international water law. Now, the interstate relevance of hydroelectric projects is more significant than in other sectors of the energy industry due to the often transboundary nature of the watercourses supplying water to the electric plants. And it is no wonder that some among the most egregious interstate disputes of the last 20 years draw from the impact of hydropower-related projects on transboundary river basins. One is just to mention the Attila case between Hungary and Slovakia, the Kishin-Ganga dispute between India and Pakistan, among others. Also telling are the numerous ongoing interstate conflicts on similar projects affecting river basins in Africa, Central Asia, and Latin America. Compliance with or infringement of large part of international law, whose immediate recipients are states, will also bear relevance for non-state actors generally, and we all know that. But this is all the more so in relation to international water law, with special regard to the corporate sector investing in hydropower projects, or to individuals or group of individuals potentially or actually affected by their construction or operation processes. In fact, carrying out development projects in coordination, if not cooperation, between the state's authorities of the state concerned and between them and the private companies, financial agencies, and the public concerned have proved to be the best way to proceed with a view to avoiding disputes and to pursue optimal results for all parties involved. As to the interstate level, it is fair to say that precisely hydroelectric power projects have prompted the development of modern international water law since the beginning of the last century. It is in that context that the three-pronged normative setting of international water law was first spelled out based on the principles of cooperation, equitable utilization, and harm prevention rules and principles. One is to recall the landmark 1923 Geneva Convention relating precisely to the development of hydraulic power affecting more than one state, adopted under the auspices of the League of Nations. It represents the formidable precursor of the now popular family of multilateral framework conventions, namely a treaty genre which became diffused only half a century later. In particular, the instrument in question was a forerunner to the 1992 UN ESIL Water Convention and the 1997 United Nations Convention on International Watercourses. The core of the framework nature of the instrument in question lies primarily in the agreement to negotiate formula. And I will turn to this in a minute. As generally stated in the preamble of the 1923 Convention, the aim of the Convention was precisely that of, and I quote, promoting international agreement for the purpose of facilitating exploitation and increasing the yield of hydraulic power, unquote. In essence, the object of the agreement to negotiate ranges from joint technical assessment of hydropower projects, possibly aimed at joint development schemes, to negotiations of agreements allowing for the development of transboundary hydropower projects, including partly on the territory of another contracting state, obviously for the maximum benefit for all co-parents involved. This conventional instrument, irrespective of the non-negligible number of ratifications, I mean, there were 11 ratifications. Nowadays, speaking of 11 ratifications, it's a bare minority. We had 193 states, but as of 1923, how many were independent sovereign states in the international community? Certainly less than 50. Now, irrespective of the number of ratifications, this instrument has served most successfully as a most authoritative term of reference for the negotiation of a formidably large number of bilateral water agreements, from its adoption through the end of 1950s. Let me mention between Italy and France, Italy and Switzerland, Greece and Turkey, but also between Germany and Luxembourg, but also Norway and the USSR, or Greece and Yugoslavia. The underpinning features common to these agreements is cooperation concerning hydropower projects on international watercourses, including the equitable allocation of the benefits and costs and harm prevention related to such projects. The significant relevance of the Geneva Convention in modern times is testified by its endorsement by the famous ILA 1966 Helsinki rules, which in their turn have provided a major term of reference for the codification by the International Law Commission, which led to the adoption of the 1997 New York Convention on International Watercourses. As already alluded, where interstate conflicts of interest evolve into differences, that is a matter of concern for states and private investors alike, and vulnerable individuals and groups of individuals alike. This is because hydropower and related projects imply a complex interplay between interstate and state investor relations, which are based on treaty, contractual, regulatory, engineering, financial, and economic relations pertaining to joint water infrastructure projects. Jane Davis Evans will certainly provide additional elements on the private stakeholders side, but from the interstate perspective, practice shows that where agreement is reached between co-reparents on the use of transboundary watercourses, win-win cooperative scenarios benefit all parties involved. To mention just but few virtuous examples, one may refer to the 1961 Canadian United States-Columbia River Treaty, geared towards the optimization for both countries of the hydropower potential of the river. It may be noted that such an agreement marked the settlement of an age-old dispute brokered by the Joint Commission set up by the 1909 Boundary Waters Treaty between the two countries. And this is another example of the agreement to agree formula at the bilateral level. It is interesting to note that according to the agreement in hand, storage dams would be built on the Canadian side with the view to ensuring power generation, together with flood control, primarily in the United States. In their turn, the United States would direct to Canada 1/2 of the additional power resulting from the project. Another agreed transboundary development scenery worth mentioning is the one stemming from the 1979 agreement between Argentina, Brazil and Paraguay on the coordination between various projects on the river Paraná. Such projects included the Itaipu Dam, which supplies water to one of the largest hydroelectric power plants in the world, whose construction also involved Italian and United States companies, amongst others. It may be singled out that next to fixing the maximum normal operational level of the water of Argentina's dam and minimum flow variations of the Brazilian project, despite the initial Brazilian resistance, the agreement provides for prior notification of information on the filling of reservoir and exchange of hydrological information. Another landmark agreement deserving our attention is certainly the 1961 Indo Agreement between India and Pakistan. It was brokered by the World Bank and involved a number of co-funding states that all exerted joint leverage towards agreement that would incorporate the basic international water law rules and principles. Today, with the primary role for the private sector, I dare say that the leverage of similar tools of financial diplomacy may have somewhat subsided. I will now briefly turn to adjudication and arbitration and their interplay with negotiation and cooperation in the field of international water law. Over the last 20 years, a significant number of international water law related disputes have been brought to international adjudication or arbitration. Reference should be made, amongst others, to Gachikovo, pulp mills, Kishinganga, and more recently to the Costa Rica versus Nicaragua cases. Even not all such cases concerned hydropower-related projects, the same procedural and substantive international rules and principles applied. Most importantly, one can draw a basic lesson from such cases, namely, that when the state hosting this infrastructural project falls short of international water law standards, apart from involving its state responsibility at the interstate level, it affects the private investors involved in projects, who might eventually see their investment postponed, impaired, or even set at naught. On the other hand, vulnerable sectors of the public may also be adversely affected. Accordingly, private operators in the field should not only be concerned with negotiation of contractual clauses and permits from a merely domestic law perspective. They may also want to consider coordinating with the public authorities so to make sure that the project in question conforms with purely public international water law standards and regulations. International water law provides procedural obligations such as those concerning notification and consultation of the planned measures pertaining to the requirement of an authorization regime under the environmental and social impact assessment procedures. International water law also sets forth substantive due diligence obligations concerning equitable utilization of the international water course in question, taking into account case-specific hydrological, geological, engineering, economic, social, and human rights consideration on a water basin specific case. The relevant international regulatory framework is to be drawn from customary international law as consolidated under the UNECE 1992 Helsinki Convention and the 1997 United Nations New York Convention on International Water Courses jointly. General international law is often supplemented on any given transboundary river basin by bilateral or regional or sub-regional watercourse agreements, about which the attorney we mentioned at the beginning of the talk should be knowledgeable about in order to best serve his or her client, be it public or private. International financial or security incentives promoting compliance and dispute avoidance with respect to international water law, as well as international environmental law, generally deserve special consideration. The World Bank, amongst the other financial agencies, is equipped with a set of operational policies on projects on international waterways as revised in March 2012. The indication of the kind of projects falling within the operational policy scope of application, hydroelectric projects feature first on the list. Cooperation and law abidance operate as a precondition for funding. It may be noted that in case of disagreement between core parties, the bank procedures on projects on international waterways on the same operational manual vest the bank with the power to trigger unilaterally a third-party inquiry procedure. I regard that this sort of financial diplomacy is very much a tool for enhancing the promotion of international compliance with international legal standards, mixing a legalistic with a utilitarian approach to the matter. A final remark on the application of international water law for the purposes of interstate dispute settlement. In the not recent legal literature, a widely diffused view has been expressed to the fact that adjudicative means of dispute resolution would not be suitable to interstate water disputes as opposed to non-adjudicative ones, characterized by flexibility and a higher degree of control over the mechanisms by the parties. And this was allegedly due to the distributive justice nature of international water law. It was clearly having in mind with the Gachikovo judgment, on the contrary, that was rendered just the year before, that Judge Schwebel, then President of the International Court of Justice and the former Special Rapporteur of the International Commission in the exercise which led to the New York Convention of 1997 on international water forces, that when addressing as President of the International Court of Justice the General Assembly in 1998, remarked as follows, and I quote, "The court is no longer seen solely as the last resort in the resolution of disputes. Rather, states may have recourse to the court in parallel with other methods of dispute resolution. The result is that in some cases political negotiations have resumed and succeeded before the court rendered judgment. In other cases, the court's decision has provided the parties with legal conclusions which they may use in framing further negotiations and in achieving settlement of the dispute." End of quotation. In Palm Mills, 3 months after the court rendered judgment, which mostly found for Uruguay, Argentina and Uruguay signed a memorandum of understanding by which they resumed water cooperation by means of a water joint body. In the final award in Kishinganga, after deciding inter alia a minimum flow of the river to be ensured, decided that starting 7 years after the diversion of the Kishinganga Nilo, either party may trigger reconsideration of the court's determination of the minimum flow through the Permanent Hindu Commission. This shows the interaction, complementarity of adjudicative with non-adjudicative means of dispute settlement. And it is to be hoped that despite the ongoing revival of unilateralism in international relations, such an integrated approach to dispute settlement will be put to full fruition by the states involved in transboundary water conflicts. And this will be fully in line with the distributive justice elements inherent in international water law. I will now turn to the domestic side of the matter, which will be certainly elaborated further by Jane. One is to mention the general trend towards the internalization of liability for transboundary harm, namely corporate liability. Such a trend, which would not automatically exclude the legal accountability of the state of origin under the international law of state responsibility, is epitomized by Principle 13 of the Rio Declaration, which reads as follows: "States shall develop national law regarding liability and compensation for the victim of pollutions and other environmental damage. States shall also cooperate in an expeditious and more determined manner to develop further international law regarding liability and compensation for adverse effects of environmental damage caused by activities within their jurisdiction or control to areas beyond their jurisdiction." End of quotation. Now, the principle has been taken up in good faith there are a number of exercises which follow up on this recommendation. First, the 1993 Lugano Convention, and then within the framework of the UNECE process under the chapeau of the UNECE 1992 Water Convention, we ended up with the 2003 Kiev Protocol, precisely on civil liability and compensation for damage caused by the transboundary effects of industrial accidents on transboundary waters. And the fact of the matter is that neither the Lugano 1993 Convention nor the Kiev Protocol have entered into force. I may elaborate on the reasons why upon stimulations from Jane, I suppose, during the discussion. But the positive fact of the matter is that those failures appear to be set up from two counts. First, domestic legislations show a diffuse trend, which is quite homogeneous within the European Union area, through the European Court of Justice case law and European Union legislation later. I've lost the page. But I found it. Well, what is this trend about? Is basically that to afford free choice to the victims of transboundary harm, namely between the courts and the law of either the state where the damage was suffered or the state where the activity was carried out, which caused the harm. Second, and very much in the same direction, one is to note the consolidation of the general principle of non-discrimination in combination with that of the equal right of hearing in the context of private redress for transboundary damage. The emergence of such two principles on the international intergovernmental plane has been boosted by the enunciation of the 1974 report of the OECD and the environment, while their formation has been enhanced by their incorporation in the 1993 North American Agreement on Environmental Cooperation, adopted in conjunction of NAFTA. And the contents of these regulations is very much in line with the Brussels and Lugano Conventions on jurisdiction and enforcement of judgments, which form part and parcel of European Union law. Their crystallization is marked by the 2000 revised protocol on shared water courses in the Southern Africa Development Community. But most importantly, by its acknowledgement and articulation in the 1997 New York Convention on Water Courses. There, state parties are to afford their judicial or administrative remedies to the victims of transboundary harm without discrimination on the basis of nationality, residence, or the place where the harm occurred. It is worth noting that here the principles in hand have been codified not only for remedial purposes, but also on the precautionary level for the benefits of those who are under a serious threat of suffering harm. And this is an interesting added value of the rules provided for in the instruments that I've just quoted. And still, in an ex-ante perspective, one is to note that the 1991 ESIL Convention on Environmental Impact Assessment in a Transboundary Context provides that the state where a project is to take place is to engage in public consultations on its environmental impact assessment with the potentially affected public on an equal footing at home and in the relevant foreign countries. And one may recall that the International Court of Justice precisely referred to the ESIL Convention despite neither of the disputing parties, namely Argentina or Uruguay, were parties to it, just because the court found that the ESIL Convention was evidential of customary law. I will now turn briefly to international investment law for the purposes of hydropower projects. And it is telling that Professor von Law, in his lectures at the Chinese Academy of International Law in Xiamen in 2006, referred precisely to disputes over foreign investment in the electricity sector in order to illustrate investment arbitration in general. Massive foreign investments in the field that flocked in, particularly in Latin America and Eastern Europe, in the wake of the privatization of the 1990s. Plenty of investment law cases related to hydropower present most traditional investment law issues. I may refer you to the 2003 award in Zimbabwe versus Georgia, 2005 in Prajil versus Pakistan, the 2009 Cementonia Nova Huta versus Turkey, and Europe Cement investment against Turkey cases, or the famous 2011 Libanako versus Turkey case. The traditional investment law issues in question included the assessment and relevance of the nationality of the investor, the definition of investment, the consent to arbitration, and the distinction between contract and treaty claims. Such issues appear to have been treated equally by the case law in this sector as in the generality of foreign investment disputes. However, one is to note that a relative dearth of final awards on merits is to be registered in this very sector, more than in any other sector. First, a great many cases in this particular field have ended at the jurisdictional phase, obviously with the preliminary objections having been upheld. Second, another significant number of cases have resulted in negotiated settlement prior to the award of the merits. I will take as one example the famous dispute concerning the expropriation of the assets concerning the hydroelectric facilities of the US corporation Abitibi Water in Canada. The case was initiated in 2009 by the company, claiming 500,000 in damages for expropriation without compensation. And after the applicant won the preliminary objections phase, the parties settled for $130 million. The often relative weakness, as I see it, in the applicant's position on the jurisdictional admissibility level on the one hand, and the inclination by the responding states to reach settlement on the other, seem to account for the two mentioned trends in the outcome of investment arbitration disputes in the sector under consideration. On both counts, special reference should be made to the high number of complex combination of the actors interacting with the foreign investor, mostly in the financial sector. They can be both private and institutional, domestic, foreign, and international. Such a complex background would in principle deter host states from adopting measures adversely affecting investments in this sector. However, when such measures are taken nonetheless, the all-or-nothing scenario offered by international arbitration is highly feared by the plurality of the actors involved in the investment from both sides of the project. As to the jurisdictional aspects, the wide variety of the financial and entrepreneurial actors, often involved through a plethora of affiliates and subsidiary companies, accounts for the classic issue to arise as to whether the investor and the investment in question qualify for legal protection under the relevant investment treaty. Investment treaties tend to afford protection for a fairly long string of foreign investors that may be involved directly and indirectly in a hydroelectric power projects, considering the four segments of the economic process, which I recalled at the outset of my talk. However, the key point is the cut-off point. That remains open for discussion. Different answers come from different investment treaties on a case-by-case basis, which is not possible to analyze in depth given the time constraints here, but allow me to refer to the general uncertainties under Article 25 of the ESIL Convention, but refer also to the ECT, which is particularly germane to our topic, which appears to be quite extensive on the point of issue. As emphasized by the tribunal in Plama Consortium versus Bulgaria, the ECT provides, and I quote, a covered investor an almost unprecedented remedy for its claims against a host state, end of quotation. A similarly extensive approach is to be found in most BITs as well as in Article 1139 of NAFTA. And it was on the basis of NAFTA that in Abitibi for water that I mentioned before, the tribunal entertained its jurisdiction before the out-of-court settlement referred to or took place. An extensive scope of the definition of investment combined with the complexity of the chain of actors and activities involved in this sector increased the chances of cross-interest between foreign investors and local ones, both private and institutional. And when a dispute arises against such a background, a similar bundle of cross-interests may play a significant factor in inducing amicable settlement. As is generally the case, this works particularly once the case has overcome the preliminary stage. I will now turn to the relevance of human rights, A, before investment arbitration tribunals, B, before human rights courts. Foreign investment in hydropower may easily become involved in the increasingly relevant debate pertaining to the interpretation and application of international investment law in connection with human rights law. On the other hand, human rights law can be applied in relation to hydropower projects directly before human rights courts. First, the operation of hydroelectric utility is subject to the requirements under the Human Rights Access to Electricity. There is no specific provision providing for such a right autonomously, but there is a general opinion to the fact that it is inherent in a number of key human rights, ranging from the right to life to an adequate standard of living and the right to health. What about a hospital falling short of electricity, for example? Therefore, Article 25 of the Universal Declaration of Human Rights and 11 of the Covenant on Economic and Social Rights clearly apply. During various stages of the process leading to the construction and operation of the hydropower plant, the entrepreneurial conduct is to conform to other human rights, like any other foreign investment activities, but taking into consideration the features of the investment in question. Since relatively recently, particularly in Suez, Saul, von Petzold, and Urbaser, investment case law has shown signs of attention for the investor's conduct according to human rights standards, primarily under Article 31(3)(c) of the Vienna Convention. This trend is increasingly reflected in the lawmaking policy as it shows from model agreements, but also to a number of new agreements. The case law confirms the primary role that host states are those who have to comply with international human rights standards, but primarily so. States have to take all the appropriate measures for public services to be provided according to the relevant international obligations and standards. But at the same time, knowledge by foreign investors of such due diligence obligations and standards may be relevant for the purposes of assessing their legitimate expectations. It is arguable that it would be appropriate for both the investor and the state authorities to take into account similar considerations from the beginning of their pre-contractual and contractual engagements. That would be with a view to avoid disputes or in order to enhance the future cases in case of litigation. To that end, guidance may be found in human rights treaties, yes, as well as in authoritative soft law instruments that seem to make up for some kind of a communis opinio juris, which is particularly germane to our topic. Let me refer to the 2007 OECD Principles for Private Sector Participation in Infrastructure in combination with the OECD Guidelines for Multinational Enterprises as updated in 2017. Out of the well-known report of the Special Representative John Ruggie, let me single out the Principles for Responsible Contracts. Thirdly, I would add the Hydropower Sustainability Assessment Protocol, which was adopted by a non-governmental, rather authoritative association in the field, namely the International Hydropower Association in 2010. The latter has become an important tool to measure and guide performance in the hydropower sector. Now, in combination with human rights treaty law, those instruments seem to offer a robust support in identifying the generally accepted due diligence standards applicable to both states and investors, as I said, with a view to avoiding dispute or to enhancing one's case in the prospect of future litigation, both from the public field camp to the private camp. So that attorney Chaptal Rosen was referring to would be well advised to pay attention also to these instruments, whether he or she would be advising governments or investors alike. Now, the entanglement between investment and human rights, particularly in the area in hand, may also lead to dispute before human rights courts. One scenario is the one in which individuals or groups of individuals file a case against the host state alleging to have suffered infringement of a basic human right from the construction or operation of a power plant or related infrastructure. Another scenario is the one in which the applicant is a foreign investor claiming violation of a right related to the investment by the authority of the host state. A specific set of human rights particularly vulnerable to investment in hydropower pertains to indigenous rights. The subject is particularly relevant in the Americas in relation to the building of dams. Two recent cases are exemplary of the pointed issue. In the four Ndobe indigenous communities and their members versus the Republic of Panama, the Inter-American Commission of Human Rights in January 2010 submitted to the Inter-American Court a request for provisional measures requiring the government of Panama to adopt with respect to the hydroelectric project, which was disputed, quote, all measures necessary to suspend the construction of works and other activities related to the concession granted, unquote. The rights invoked to be at risk included the right to life, to freedom of movement, and to special relationship to the ancestral territory, including collective property and natural resources therein. Threats to such rights, which were claimed to consist of the prospective flooding, deforestation, displacement, relocation, and diseases linked to the massive influx of people into the region, as well as related diseases such as malaria. The court rejected the request for failure to demonstrate prima facie the situation of extreme gravity, urgency of preventing irreparable damage. However, the court felt the need to make a number of rather extensive obiter statements that have quickly developed into a jurisprudential classic in combination with other authoritative statements of a jurisprudential and non-jurisprudential nature. The court, in particular, emphasized that the American Convention does not prohibit the issuance of concessions as such, for the use of natural resources in indigenous territories. However, it set forth a number of requirements. 1. A prior environmental and social assessment. 2. Prior consultations with the affected communities. 3. When dealing with a large-scale development, the informed consent of the communities, conforming to their customs and traditions, has to be carried out. Lastly, the reasonable sharing of benefits, basically compensation or indemnification. The communities had claimed that their life and physical integrity were jeopardized in the construction of another project, the Belo Monte Hydroelectric plant in the Amazon. The case was brought before the Commission in 2011, and immediately the Commission requested the state of Brazil to suspend the licensing process and to stop any construction work until certain minimum conditions of the kind just mentioned would be fulfilled. It is interesting to note that the requirements set forth by the Inter-American Commission and Court of Human Rights in those two cases fall squarely within the standards codified by the 1998 UNECE Aarhus Convention on access to information, public participation in decision-making, and access to justice in environmental matters. This is an instrument that swings between environmental and human rights bodies of international law. And it is no wonder that the same standards have just been codified in the ECLAC, the UN Economic Commission for Latin America and the Caribbean. On the same topic was adopted a few weeks ago on 4 March this year and will be open for signature at the United Nations headquarters on 27 October or September this year. This development in Latin America accounts for the intricacies of the frequent domestic law controversies in the field, which are entangled with international human rights litigation standards. In fact, going back to the Belo Monte hydroelectric plant dispute in the Amazon, first the Brazilian government rejected the suspension order of the Inter-American Commission on Human Rights. Immediately after, Eletronorte, 60% state-owned Brazilian and 40% privately owned, was granted a license to build the world's 4th largest dam, Belo Monte. Subsequently, the Inter-American Commission received a joint submission by governmental authorities and representatives from the affected populations, additional information meeting their requirements. So all well. April 2016, a few weeks before the inauguration of the turbines, a federal judge in Brazil suspended the dam's license, fined the company, while a number of criminal lawsuits have been started in connection with the failure by the company to live up with its obligation to complete due social and environmental projects. Much the same legal intricacies arose in Spain in relation to an administrative lawsuit filed by the potential victims of the construction of the Itois Dam in the Navarre province, which would result in the flooding of 3 nature reserves and a number of small villages, including Itois. The case, Gorais-Lizarraga versus Spain, eventually ended before the European Court of Human Rights, based precisely on the claim that the right to access to justice and of due process of law had been infringed by Spain. In 2004, the court found for the respondent state. But these are the kinds of international law issues intersecting with domestic law that an attorney may be confronted with in relation to the construction of a dam in Europe as much as in Latin America, or Africa, or Central Asia, or anywhere else. One may refer to the Uzan versus others, and others versus Turkey, decided in 2011 by the European Court of Human Rights. Again, two subsidiary companies of the Uzan Turkish group had respectively obtained 2 concession contracts valid until 2058 for the production, transmission, distribution and sale of the electric energy generated by 2 hydroelectric plants in Turkey. The whole economic process in one package. In 2002, the government unilaterally terminated the contract in compliance with legislation passed the year before, which prevented concentration of all 4 activities in the hands of one sole company. The court found the defendant state, ruling that the claim for the alleged expropriation was manifestly ill-founded. The court found for Turkey, in the first place, found that the measures adopted met the public interest legality criteria, which was the purpose: improving the domestic electricity market through liberalization and competition. Importantly, the court reached its conclusion taking into account that the Turkish government at the time was conforming to the liberalization standards recommended by the World Bank, by the International Monetary Fund, and provided for also by European Union legislation. In the second, and no less importantly, the disputed governmental measures, including the non-payment of compensation for the unilateral termination, were found to be justified as a reaction to the repeated breaches by the applicants, consisting of failure to apply the agreed tariffs and to make the necessary investment to produce and distribute sufficient electricity to satisfy the demand. So shifting the burden of performance of public utility in the country by the basic international human rights standards. There's the end, and we come to the conclusion. One would highlight the overarching character in a significant number of rules and principles cutting across 2 or more of the different bodies of international law that we have looked at today. They are both procedural and substantive rules and principles. Suffice to refer to the obligations of information and consultation, to the right of access to justice according to the principle of non-discrimination, or to the environmental and social impact assessment principle applying on the domestic and transboundary levels alike. One would add the right to electricity or other fundamental rights that also apply on the domestic level within the framework of international human rights law, as well as on the transboundary level in relation to the social and economic factors making up both the equitable utilization principle and the harm prevention rule. It emerges from this specific consideration that next to the horizontal interaction between bodies of international law, there is also a vertical perspective to it, namely the interaction between international and domestic rules. Such a vertical normative interplay works at the lawmaking process level first, and at the international implementation level later. This is self-evident with regard to investment law and human rights law, but it is also apparent how by complying with international water law, either state authorities or private actors would contribute to ensuring dispute avoidance or to strengthening their case in future litigation, be it before an interstate adjudicative body, a domestic court, a human rights court, or an investment tribunal. Well, thank you very much for bearing with me. Thank you. I very much hope that Jane can put much muscles and meat and substance to the bones.
Well, Professor Tanzi, thank you very much for giving us your analysis of a very complex legal landscape, actually, and showing us how research and practice can really be linked together. So now it's my pleasure to welcome Jane Davis-Evans, who is a barrister at Vivarolin Buildings, and she will give a few remarks and comments about the talk. Thank you.
Thank you. So I'd like to start by thanking the Dixon Proof School of Law for inviting me to give the response, and in particular to Professor Tanzi for suggesting that I might be an appropriate person to do so. Now, I anticipate that a number of you sitting here might be wondering why he asked someone like me, who focuses on the very practical disputes that emerge in the dirt and the dust of construction, a legal brickie, as we're sometimes described, to respond, rather than one of the many illustrious public international lawyers who practice in London and the UK, some of which are in the room. And I shared those thoughts and wondered what I could possibly hope to add to what Professor Tanzi was saying. However, I had the good fortune last night of being given an early draft of what he was going to say, and I have to say the mist cleared. I am the lawyer who Professor Rosen had in mind when he spoke of the non-public international lawyer who, somewhat reassuringly, he did not expect to know the answer to the issues of public international law, but he rather hoped, although I think doubted, would have the ability to recognise that there was a problem of public international law, and would have that sufficient understanding to recognise there was at least something there. Now, as Professor Tanzi said this evening, and Professor Rosen has noted before, what is important is that I recognise that there is an issue, even if I'm not always sure what that issue actually is. But what is absolutely critical, in my view, is that you know a man or a woman who does know the answer to that public international law issue. And in Professor Tanzi and in others in this room, there are certainly people who know the issue and know the answer, in particular when the problem relates to international water law. And I also hope that in a very small way, in the next 10-15 minutes, I might be able to contribute to some of the constructive elements of legal realism identified by Judge Greenwood, and to which Professor Tanzi also referred at the start of his talk. Now, I think it's compulsory nowadays, if you're giving a talk on international arbitration law, to mention diversity at some point. And diversity is very much an issue and a feature in the world of hydropower schemes. There is a world of difference between the handful of mega projects, the Three Gorges Dam in China, Itaipu in Latin America and the like, where you're talking of capacity in excess of 10,000 megawatts, and the majority of hydro projects that are in operational development. Indeed, if you look in the UK or much of the world, what the majority of these projects by a mile are micro hydro projects. They're domestic. There is no issues of international law whatsoever. They've got capacity of probably less than 100,000 of these major projects. That is the market where it's booming, not in these mega projects. But they don't attract so much attention, in particular amongst the lawyers. There's also a diversity of purpose. While many hydro projects are used for the base load, so the daily requirements of the country, others, and it's very different technology, are there to provide the peak load support. And geographical location and climate are of course very key, but so important to understand. And the number of times that people sometimes forget, I've been in international arbitrations where an expert talking about a project in Africa genuinely said to me in response to issues about climate, Africa is a diverse country, but the weather is basically the same. And so you are saying that the weather in the Sahara Desert is the same as in equatorial countries? And he said it's very diverse, but basically the same. And at that point, he lost all credibility with the tribunal. But because of these variations, the output can vary dramatically. Some plants have a huge difference in the output depending on the time of year and the levels of the river or the dam. Other schemes have been constructed in a way which means there's a relatively constant flow. And that's very important if you're involved in hydro project schemes at the beginning, if you're looking at financing, for example, because the financial models that are often used to support these very much depend on understanding the commercial output from these plants. You need to have your long-term supply agreements in place in order to achieve financial close. And again, this is very much dependent on how consistent the power will be that's produced by these plants. I think we also need to be careful when we look at the impact of climate change on hydropower as well. And it's certainly true to say there are certain parts of the world which traditionally have been very reliant on hydropower as their baseload supply, have suffered terribly in recent years through abnormally low, prolonged periods of low rainfall, which has in some areas really had catastrophic effects on the economics of these plants, not only the plants themselves, but then enforcing up the power price generally has catastrophic effects on the overall economy. And there have been some instances where governments have been brought down by this, so it can have huge political and economic implications. But in other parts of the world, there's now substantially more rain. Rainy seasons are longer and more frequent than they used to be. And these are some of the places where we're now seeing hydro projects being constructed, where they wouldn't previously have been economically viable. And while there have been some, there are undoubtedly transboundary projects which cause disputes, give rise to political tensions, or end up in potential disputes for the international courts. As Professor Tanzi had identified, there are other projects which have undoubtedly brought states together to work together for the common good, and over a long-term period as well. But enough about diversity, and just back to my very small attempt to make a very tiny contribution to the development of international law in this field. And listening to Professor Tanzi this evening, and as I said, I was fortunate to have a short preview of what he was likely to say, I was struck both by the difference, but also potential similarities between the international water law and also comparable provisions we see in relation to nuclear liability that applies in relation to nuclear power plants, which is one of the few areas of international law that I do come across on a fairly regular basis in my practice. Now, the Chernobyl nuclear disaster provided the clearest reminder in recent times that nuclear damage does not respect international borders. Notwithstanding the significant emphasis on nuclear safety in the nuclear projects, a nuclear incident, if it does occur, has greater potential to cause damage across a widespread geographical area and population than almost any other form of energy production. Now I said almost, because while there are fortunately very limited examples of catastrophic failures of hydroelectric schemes, there's certainly scope for widespread loss of life and property were a major hydroelectric scheme down to fail. The most significant recent failure occurred back in 1975 in China, and then 2 dams failed in the Henan province, and this was a result of Typhoon Nine, a so-called once in a 2,000-year storm. So the dams have been constructed to deal with 1 in 1,000-year events, which is far beyond what most major civil infrastructure is designed for. But this typhoon came in particularly bad. It was so bad the Chinese government were actually bombing dams along the river to try to release the flow. But this particular very large dam failed. The life lost was catastrophic. Estimates range between 90,000 and 250,000 people died. The flood that came out from the dam was estimated to be 10 kilometers wide, 7 meters deep, and traveling at 50 kilometers an hour. I mean, it was a truly biblical catastrophe of a scale that matches anything that could come out of a nuclear disaster. So looking at how the nuclear industry deals with this, now liability for nuclear damage suffered within the jurisdiction of a nuclear civil facility, and I'm focusing on civil facilities, not military nuclear installations, is dealt with by the local legislation in the court. But turning to the international sphere, and there's a very sophisticated regime of nuclear liability conventions. Now, so many states have signed up to the conventions, and states you might not expect, Russia and China hasn't signed up to many, but it has equivalent domestic legislation that's also involved in the international insurance pooling, so you've got the equivalent cover there. Now, tonight's not the time or place to deal with that in detail, but suffice to say, you've got this major international conventions which are signed up, and although they're different conventions in different parts of the world, they all approach the issue in the same way. And they have the same basic principle, which is channeling. They channel liability for nuclear damage to the operator. So if the operator has the liability for damage, and it's channeled exclusively, the operator's liability is absolute. There are very few limitations in relation to war and other things. Absolute liability for nuclear damage. Now, the quid pro quo to absolute liability is there is a cap, but it's a very high cap on liability. And also, the operator has to commit to either insurance or security. There's big international nuclear insurance pools that are largely used to do this. And they must maintain that liability. The state court of the jurisdiction where the facility is located has exclusive jurisdiction. So if you're in a different country and you suffer damage and you sue in your home country, that country, if it's a contracting state, should refuse jurisdiction. You're meant to go to the court. It's very focused and a way of dealing with the liability. You also have to bring the claim within a fixed period of time. It's typically 10 years. So this channeling of liability to the operator means that the suppliers, the construction chain, all of the vendors of key components, etc., they should not face direct claims themselves. If you go to the operator, there's sort of single source liability. You might still get claims that flow down depending on your contracting arrangements, but the claim for the individual who suffered damage knows where they go. They know the court, they know who they go against, and they know that theoretically the money is there, because these conventions also say if the money isn't there because the insurance fails for some reason, the contracting state has to make up the difference. So there's really clear protections. Now, I think it's true to say that nuclear incidents, be it 3 Mile Island, Chernobyl, or more recently Fukushima, have an almost unique impact on the human psyche. It's that unstoppable but invisible threat creeping imperceptibly towards communities who are just lying, waiting, entirely at the whim of the prevailing wind as to whether the damage comes to them or someone else. That threat then lurks unseen but omnipresent for decades, not only causing death and immediate aftermath for those close to the facility if it's a catastrophic failure, but increasing the risk of long-term health problems, cancers, birth defects and the like, both for humans but the animals, the food chain. So it's perhaps not unsurprising that there has been the political will to create international liability regimes based on absolute liability backed by the states financially, which hasn't occurred, as far as I'm aware, in the international water community so far. But I think that as water becomes an ever increasingly valuable asset, and also as these mega dams, these mega projects continue to be constructed on some of the world's most significant rivers, with major population centres, if not entire civilizations, increasingly both dependent on, but incredibly vulnerable to these hydro projects. It may be that there will be a tipping point at which it is deemed politically expedient, if not necessary, for similar liability regimes to be introduced for major hydropower schemes, and indeed for any major dams, both in relation to failures, but also to environmental and property damage, and also the very humanitarian damage that can occur if those reduced water flows, the reduced water quality that Professor Tanzi mentioned, flow down literally through the river. And one hopes that tipping point will not, as too often is the case, as history showed, follows catastrophic loss of life or armed conflict, and that in fact the community will come to realise that this is a useful way forward to avoid and resolve disputes independently. I'll finish my response on a slightly lighter note, because that was a little depressing, with 2 examples of legal and practical issues that construction lawyers like me have to grapple with when we're advising in relation to these trans-border projects. Now, of course, something everyone will be familiar with in this room is Eurotunnel. I mean, hopping on the train to Paris, to Brussels, Aix-en-Provence, or wherever seems completely normal now. But back in the 1980s, construction lawyers on both sides of the Channel, or La Manche, were grappling with what applicable law to apply to the construction contracts for the tunnel. Now, I'm sure many of you will be familiar with the very political compromise. The principles common to both English and French law, and in the absence of such common principles, such general principles of international trade law has been applied by national and international tribunals. That was the applicable law of the construction contract. The compromise in relation to arbitration was somewhat easier. They just said they'd go to Brussels. Perhaps not unsurprisingly, that choice of law clause, while politically expedient when trying to get the contract over to signature, proved a fruitful source of work for lawyers for both in litigation and arbitration for many years. But more recently, I was asked to advise on a transboundary project between two unnamed states. And it was acknowledged that the Eurotunnel applicable law clause was not the way to go. I think everyone realised that, and we had banks who'd been through this process before, so did not want to go near that. Now, the solution that was proposed at the time I was there sort of seemed sensible on one level, and it certainly matched the political imperatives of the states. So the plan was that the contractors from State A would build to a design from a designer from State A, and would be paid by State A in a contract with State A, which would be governed by the law of State A. And this other would happen for State B. Now, this all sounded quite sensible. Before I raised a very practical question, and you do find as a construction lawyer, you actually spend most of your life raising the very practical questions, not the legal questions at all. So my questions were, okay, but what design are you planning to build? Where, if it's a bridge, where is the pillar going to be? Is it going to be on the border? If so, who's going to build the pillar? We'll build half each. Okay. Structurally, how is it going to fit together? Are there going to be tensile cables coming across, which normally happens? What about the communications cables? All of these very basic, actually engineering issues. It's not law. Now, I'm pleased to say I'm not involved in the project anymore, but it's underway and very nearly finished. But in the end, it was the practical realities, the practical engineering realities that actually won the day. But I tell that story just to emphasize that it's not just the legal realities that need to influence the development of international law in relation to major projects. But dare I say it often, actually the practical construction realities are really the drivers to getting these projects over the line successfully.